Evening.
Oh, there it is, recording in progress. It's just telling us that. So there you go.
And you guys are ready on your end with that?
We are.
All right. I'm gonna give it 30 more seconds.
Yes.
Okay, we'll go on the record. The time is 6 p.m. on December 7th. This is the continuation of the hearing for Deschutes County file number 247-21889AD, which is a request to establish a wireless telecommunications facility on property in the exclusive farm use zone. My name is Tommy Brooks, and I am the hearings officer in this matter. We are in part through electronic means. So before we begin the substantive part of the hearing, I'm going to turn things over to Mr. Regini to describe how the virtual process works.
Sure. Thank you, Hearings Officer Brooks. And what I'm going to do is I'm going to share my screen. I'm going to put a PowerPoint up on the screen here so I can go through sort of the Zoom instructions so that everybody understands how we're going to proceed. So is that Hearings Officer Brooks, are you seeing the full screen there?
I do see it, yes.
Perfect. So as Hearings Officer Brooks said, there's a hearing for AT&T Monopole. For the record, my name is Anthony Regini. I'm a senior planner with the Community Development Department. And for those who are either attending with us again or are new to this particular hearing, I did want to note, as Hearings Officer Brooks said, this is a continuance, and the initial public hearing was open on November 9th. And the applicant requested a continuance to tonight. Actually, I have December 6th on the screen. It should be December 7th. To address a submittal that was made by an attorney for Gary Sherman. The attorney is Dan Kearns. So that's the purpose of tonight's hearing. With respect to hearings procedure, what we're going to do is I'm going to start with, again, explaining how we're going to sort of interact on Zoom and if we have any telephone participants. The hearings officer following those instructions will provide hearing instructions, staff will provide us its report, and then we'll go into the sort of public testimony portion of it, and that'll start with the applicant, followed by interested persons. And you'll note when we get to that place, and I'll talk about it a little bit more later, I'm going to group everybody into support, neutral, and opposition. And so I'll explain that here in a minute. At the end of the public testimony, the applicant will be provided an opportunity to present rebuttal testimony. And then staff will be afforded an opportunity to make any closing comments. And at the end of it, and I'll talk about this also in my oral presentation, we'll have a discussion regarding an open record period, which I'm sure Hearings Officer Brooks will also address. So with regard to Zoom, if you're joining us via Zoom, know that if your connection is interrupted, use the same link that you were given in order to log back in. It's going to take a couple minutes. And then hopefully you'll be able to get back on. If my own connection, the county's connection, is interrupted, do me a favor, give us a couple minutes to get logged back into the meeting to fire it up. And then in a couple minutes, go ahead and use that same link again to get back into the meeting. And for the purposes of Zoom, you're either a panelist or attendee. And the distinction between the two is pretty important. As a panelist, as an attendee, you'll be elevated to a panelist when you are called to testify. And the reason why this is important is that panelists, you will have your audio and video recorded. You do possess the ability to mute your microphone and black out your video, and I'm going to show you the controls for that here in a second. Panelists, again, will have their audio and video recorded. However, attendees are not on audio or video, and that's why it's important when we call you for testimony, you will be elevated, and it takes a couple seconds for that elevation to happen. So be patient, and it'll take, again, a couple seconds for that transition to happen. As an attendee, if you look at the bottom portion of your Zoom screen, you'll notice a number of tools and buttons. On the far left is the mute button with the microphone there, and you can mute your audio. You also have next to it the stop video button to black out your video. I point these out because there are times when someone who is testifying may want to confer with their legal counsel, or the legal counsel confer with their client, and you don't want that to be recorded. So you can use the mute and stop video buttons to prevent that recording, and then come back to us when you're ready. What I would ask you to do, though, if you plan on conferring with either your counsel or your client, that you let the hearings officer know that you're going to do so that we are aware that you're going to be not recorded for that period of time. So if you wish to testify, and we'll go over this again in a couple minutes, sort of how that's going to happen. But if you're on Zoom right now and you wish to testify, what I want you to do is to press the raise hand button. So that's in the bottom center of your screen. And what we're going to do is sort of categorize or put everybody into groups, depending on whether or not you want to testify in support, opposition, or if you're neutral. So I'm going to switch over and stop share screen for a second so I can look at the attendee list. So again, if you are on Zoom and you wish to testify, do me a favor and press the raise hand button. And then what I'm going to do is I'm going to have the producer, I'm going to call you out one at a time and have the producer elevate you to panelists so that I can get your name, your address for the record. And then again, ask if you wish to testify in support, neutral, or opposition. And at this time, I see hand raised Daniel Kearns. If I could, producer, if I could have Mr. Kearns elevated to panelist. Okay. And again, Dan, give it a couple seconds for us for the transition to happen. I suspect I know what category you'll be in, but just for the record, we'll get your name and address also. There you are. Dan, can you hear us?
I can. Can you hear me?
I can. So by the way, am I pronouncing your last name correctly?
Yes.
Okay. So if I could get your address for the record, please.
It's 621 Southwest Morrison Street, Suite 510, Portland, 97205.
Great. And Dan, I presume you're testifying in opposition?
Yes.
Awesome. So I'm producer, we could go ahead and move Mr. Kearns back to attendee, and I'll go back to the list.
Thank you.
If there's anybody else on Zoom who wishes to testify, please press your raise hand button. If you're the applicant, you don't need to press the raise hand button. You'll be elevated when the time comes for your testimony. And that looks like it's it, Hearings Officer Brooks. It's just Mr. Kearns who has raised his hand. I do have one person in person who also wants to testify. At this time, if producer, if we could have the camera on the testimony table, and we'll get a name and address also. Go ahead.
Diane Burns, 61415 K-Bar Road, Bend, Oregon, 97702.
And I presume, Diane, that you're also going to testify in opposition?
Yes.
Okay. Perfect. Thank you, Diane. So Hearings Officer Brooks, looks like we have two so far, and I will notify you if we get more people who come in during the course of the hearing.
Okay, thank you.
I'm going to go ahead and go back to share screen and complete the PowerPoint presentation. So at this point, we've sort of covered those who are on Zoom, and I will note for the record, no one has joined us via telephone. So the Zoom hearing procedure. So please be aware that staff and the hearings officer are responsible for ensuring an orderly hearing. So conduct which is not appropriate to the hearing will be addressed by staff and the hearings officer and may result in your being removed from the hearing. So please, let's be respectful of everyone so that we can have a hearing and get through this relatively smoothly. If you wish to submit testimony to the record, you can do those in a couple of different ways. If you're in person, you can certainly submit any written materials to me in person, and I will note those in the exhibit schedule for the record. If you have items that you want to submit via email, I have my email address on the screen. It's anthony.raghini@deschutes.org. I will note, though, for electronic submittals, and this is really important for everyone, all parties to be aware of. If your submittal is greater than 20 pages in length, includes any color figures, or must be printed larger than 8.5 by 11, in addition to your electronic submittal, you must submit a hard copy. And so I make this point because, frankly, this is the joke I use and it's corny, but we're not Kinkos. So we don't print out what sometimes are hundreds of pages of submittals. So If you have a submittal that exceeds any one of those three criteria, then you must also submit it as a hard copy. At this point, I'm going to ask, and I'm going to, again, stop share screen so I can see the attendee list. Is there anyone either in person or attending via Zoom who wishes to object to the format of the hearing, which is both, again, in person, Zoom, and potentially telephone? If you do object to the format of the hearing, if you're in person, please let me know, or if you're in Zoom, please press the raise hand button. And no one at this time is objecting to the format of the hearing, so I'm going to continue. So at this time, I'm going to turn it over to Hearings Officer Brooks for your hearing instructions.
Hey, thank you, Mr. Regini. This application is being considered through a quasi judicial process, and so as the hearings officer, I will consider only the factual evidence that is in the record. I will then apply those facts to any relevant provisions of the county's comprehensive plan and land use regulations. The standards and applicable criteria relevant to this hearing were identified in the public notice announcing this hearing. They are also set forth in the decision. They are also set forth in the staff report. The public notice and the earlier staff report are posted on the county's website. They're also available. It is important that you direct all your testimony to the standards and applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criterion. However, I urge you to also explain why the criterion must apply and to do so with specificity so that other participants may respond and so that I can address that issue in my decision. The failure to raise an issue with enough detail to enable me or the other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed conditions of approval with enough detail that allows me to respond to the issue in my decision precludes an action for damages in circuit court. I serve as the county's hearings officer, and in that role, my job is to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I am obligated to remain impartial, and I do not represent the county's interests or the interests of any participant. To that end, I'll state for the record that I do not have a relationship with the applicant. I do not know, I have not made any sort of site visit, and I do not have any ex parte contacts to disclose. I have communicated with staff, but only to discuss the particulars of the hearing and not the substance of the application. The hearing is going to be conducted set forth in the county's code in the following order. The staff is going to present the staff report. The applicant will then be invited up to present the application. We'll follow that with, it doesn't sound like there's anyone in favor of the application, but if anyone does show up, they would go next. Then we have our two people who have signed up in opposition. If desired, the applicant can then appear in rebuttal. As a last step, I'll invite staff up for any final comments. And I may have questions for staff at that time too. I don't anticipate setting any time limits for participation, given the few numbers we have here tonight, but I do reserve the right to do so. And I guess before we begin, does anyone wish to challenge my ability to hear this matter or to challenge the county's jurisdiction over this matter?
So for those of you joining in Zoom, if you wish to challenge the hearings officer's ability to conduct this hearing, please press the raise hand button. If you're in person, if you would notify me if you wish to challenge. Hearings Officer Brooks, no challenge.
Okay, and as a final comment, I've had a tough time this week with my internet service for some reason. So if at any point, Mr. Regini, if I'm cutting in or out, if you do your best to get my attention, I may need to call in. I might also turn off my video. That seemed to help on an earlier thing this week. I wouldn't do that while I'm talking, but while I'm listening, I might turn it off. So with that, I will turn it back over to Mr. Regini for the staff report.
Thank you, Hearings Officer Brooks. And I'm going to go back again to the PowerPoint. So, and this is all this figure is in the record, but I just wanted to sort of orient everybody. I think everybody probably knows where this is. This is a location map that shows the general location of the proposed facility. And this is a close-up of it that shows sort of this little interesting notch out with the Highway 20, what I believe to be the right-of-way and the location of the facility. The project details, so it's a 150-foot tall monopole with a 5-foot tall lightning rod. So the total structural height is 155. The applicant also proposes a 50 by 50-foot fence lease area, which will include the equipment cabinets and the backup generator along with the tower itself. So here's a sort of an elevation drawing of the monopole. At the bottom of the screen, you'll see sort of the fence area, the cabinets, the generator, and of course the monopole itself. There were a couple of issue areas that I raised in my staff report that I'm sure both sides will discuss this evening. And one of the things I pointed out in the staff report is the applicant has made essentially two arguments as to how the facility could be approved. One is a roadway project and one is a utility facility. What makes the arguments interesting is that as the roadway project, should the hearings officer decide that it is a roadway project, that use is allowed by right and does not require land use approval. Whereas the utility facility necessary for public service does require land use approval. So again, I point out that the applicant has offered sort of two avenues for approval of the project. The applicant has argued that via Brentmar, other local county standards that are not in statute or rule do not apply. And in this case, sort of the one that has garnered the most interest is the landscape management combining zone. And I'm going to talk a little bit later about a submittal we received from the applicant regarding the landscape management combining zone. And again, the applicant argues it doesn't apply. The opposition argues that because the LM zone essentially is required, authorized by Goal 5, that it should also apply. There are questions in the record with regard to whether or not the applicant did a sufficient job of identifying reasonable alternatives. In particular, Mr. Kieran's letter discusses or argues that the applicant did not do enough and made essentially general statements with regard to the unavailability of other non-EFU or non-resource zone lands. And then there are arguments in the record with regard to whether or not the applicant has adequately addressed whether or not the facility must be sited on EFU zone land. And again, I think that's also tied to the alternatives analysis. One thing I want to point out, yesterday, the applicant submitted a document and exhibits for this continued hearing. So that was yesterday. And in that, and I want to sort of point out, and I'll talk about it here in a second, is a correspondence from the county building official regarding the need or the whether or not a building permit is required. Dan Kieran's attorney for Gary Sherman submitted an email earlier today requesting that due to the amount of information submitted by the applicant yesterday, that the initial open record period be left open for 28 days. I do not recall if Mr. Kieran's suggested a rebuttal period, but I'm sure he'll address that when he testifies. But I did want to put that on the record that there is already a request for an open record period and that the initial open record period be 28 days. With respect to the building official, as part of the applicant's submittal, I believe it's Exhibit A, the applicant submitted correspondence from the Deschutes County building official indicating that a building permit is not required for this facility. And the reason why that is important is under Deschutes County Code or DCC 1884-050A, non-agricultural structures trigger landscape management review when a building permit is required. And so from staff's perspective, once the building official determined that a building permit is not required, then the provisions of the LM zone do not apply. And again, as I noted, per the applicant's submittal yesterday, they included an email with the building official's determination on the building permit requirement. So I did want to point that out because there was a lot of time spent on both sides on whether or not LM applied. And at this time, staff is available for questions. And I'll stop my share screen here too.
Thank you, Mr. Regini. I don't have any questions for you at the moment. I may at the end of the hearing. So with that, we can have the applicant. I don't know if it's the applicant or applicant's representative.
And so, producer, if we could elevate Kim Allen and Ken Lyons, they'll be doing, my understanding is those two will be doing the presentation for the applicant this evening.
And if I could, we got the names and addresses of people who testified earlier, but for both the applicant representatives, if you wouldn't mind starting off with your name and address.
Good evening, Hearings Officer Brooks. My name is Kim Allen. I am with the Wireless Policy Group. Our address is 1420 North Gilman Boulevard, Issaquah, Washington, 98027. And I am here this evening with my two colleagues, Ken Lyons and Meredith Pabst from Wireless Policy Group on behalf of the applicant.
Kim, did you want me to have Meredith also elevated to panelist?
Yes, please.
Thank you. And Ken, if we could get for the record, your address.
Yes, my name is Ken Lyons here on behalf of AT&T, and my address, same as Kim, 1420 Northwest Gilman Boulevard, box 9030, Issaquah, Washington, 98027. And just so I can check, is my screen showing? Do you see the presentation?
We do.
Do you see the presentation?
I do. And it's on the screen in the room as well.
Thank you.
And Meredith, if you're online, your address as well.
Yes, good evening. You may use the same address for me.
You
The
guys want to
Gilman
make it
Boulevard address. Thank you.
Kim and
So you-
Ken, Meredith, I think if you guys are ready, you can
Yeah.
get started.
Go ahead.
Very good. Thank you very much. As a preliminary matter, I would like to request to admit this PowerPoint, the response to the opponents, and the supplemental exhibit packet that we submitted to the planning department yesterday, and have them included in the record here. All right. The project that's being proposed here by AT&T is to build a 150-foot wireless tower in available ODOT right-of-way on US 20 Central Oregon Highway in unincorporated Deschutes County. The right-of-way is located in the EFU zone and within the LM combining zone. Now, this tower will fill a significant gap in 4G LTE coverage for the AT&T network and will add band 14 coverage to serve the FirstNet network. Next slide. And here's an overhead of the site. As you can see, there's a portion of the right-of-way that expands a little right in that area, and that is where the site is proposed. It's adjacent to the Central Oregon Irrigation District canal crossing there. Next slide. And this is a photo simulation of the proposed tower looking west towards the proposed facility from the east. You'll notice that this is in a rather established transportation and utility corridor with similar types of infrastructure visible in the photograph here. Next slide. So I mentioned FirstNet, and I wanted to give the hearings officer a little background on that. FirstNet is a federally mandated network built by AT&T under the FirstNet Authority under the supervision of the U.S. Department of Commerce. It's a 25-year contract awarded to AT&T, and the state of Oregon opted into FirstNet along with all 50 states, 5 territories, and the District of Columbia. And the Oregon State Interoperability Executive Committee identified the specific need for better FirstNet coverage in this very area. Nationwide, interoperable broadband network is needed for public safety and to give reliable communications to first responders in the event of an emergency. Band 14 spectrum and AT&T also provides priority and preemption for FirstNet users on all LTE frequencies on AT&T's network. So they will get first shot at the bandwidth that's there. Next slide, please. And this is just a graphic kind of outlining the types of first responders and users that will have the benefit of FirstNet, allowing them to send and receive data, video, images, and text without concerns about network congestion. So next slide. So there are two issues that staff has submitted for decision tonight on this application. Issue number one is, do the provisions of the LM combining zone apply to this project? And issue number two is the proposed project a facility allowed in the EFU zone under ORS 213 or 215.275 as a utility facility necessary for public service. Next slide. As to the first issue, by its terms, the LM combining zones requirements for site plan review and compliance with the 30-foot height limit apply only to projects requiring a building permit. This tower is in the right of way and so is exempt because construction is located in the public right of way. There's an exemption from building permit under the building code in Oregon Specialty Safety Code section 101.2.2.1 subsection 19. So the county building official in concert with the county attorney has concluded that this project does not require a building permit because it is construction in the right of way. And AT&T has withdrawn its building permit application for that. And the correspondence on that and the withdrawal of the building permit are found as exhibits A and G in the supplemental packet submitted yesterday. Next slide. So issue number two is compliance with ORS 215.275.2. And while under that statute, only one factor is required to demonstrate that the facility is necessary for public service, AT&T has shown under 4 factors out of 6 that the facility is necessary for public service in the EFU zone. So those 4 factors that AT&T satisfies are availability of existing right-of-way, technical and engineering feasibility require a presence in the EFU zone. The facility is locationally dependent, and there's a lack of available urban and non-resource lands. Next slide, please. So AT&T meets its burden under ORS 215.2752 solely by showing that the facility is proposed to be located in the existing available right-of-way under factor 2D. The facility is unquestionably proposed to be located in the right-of-way as confirmed by ODOT in a correspondence which we have included in your supplemental packet as exhibit B. Also, this corridor, Highway 20, is very apparently a non-farm use. It's a transportation and utility corridor devoted long-term to non-farm uses and available for the location of AT&T's FirstNet facility. Next slide. In fact, AT&T submitted its lease with ODOT for this site. It was included as an exhibit with the original application, and the lease clearly shows that the facility and the equipment area proposed are within the ODOT right-of-way. Next slide. So in addition to satisfying its burden of proof under ORS 215.275 by demonstrating that this is being cited in available right-of-way, AT&T is also submitting additional documentation to show that, that technical and engineering feasibility requires a presence in the EFU zone. And to that end, we have submitted for your consideration an updated RF justification that provides detailed technical analysis explaining the need for the facility to serve what it is predominantly EFU properties. And that's included as exhibit C in the supplemental packet submitted yesterday. We also discussed in that document, AT&T's facility is needed to address a significant gap in 4G LTE coverage and also to add band 14 coverage for FirstNet. Because not only will the facility provide FirstNet service through band 14, but AT&T will provide priority and preemption on all its commercial frequencies, supporting FirstNet on all of those frequencies that it operates in this facility in the event of an emergency. Next slide, please. So we've satisfied the feasibility, the technical feasibility factor previously discussed, and move on to factor 2B, that the proposed facility is locationally dependent. And as described by ORS, a utility facility is locationally dependent if it must cross land in one or more areas zoned for EFU in order to achieve a reasonably direct route or to meet unique geographic needs that cannot be satisfied on other lands. And we've included some previous county decisions in the supplemental packet for the hearing officer's consideration, where they've explained that while a cell tower does not cross land in the same sense as a utility line, its RF signals do cross land where wireless service is provided in EFU zoned areas. So it clearly meets the definition and the test in the ORS for locationally dependent. And the specific considerations here are that the site's location is within AT&T's search ring, all of which is in the EFU zone. The principal purpose of the facility is to improve service along Highway 20, all of which is in the EFU zone in this part of the county. And most of the land within the larger targeted service area for this facility is zoned EFU. And the areas that are non-EFU parcels, RR10 and MUA, appear mostly on the fringes of the larger AT&T target service area and are entirely outside of the AT&T search ring. Next slide. So moving on to the fourth factor, factor 2C, we need to demonstrate that there are no feasible and available alternatives on non-resource land. And before the November 7th hearing date, Mr. Kearns presented a letter that detailed a number of proposed alternative locations for this site. We addressed all of those either with our RF justification or the alternative site analysis. In fact, though, many of the alternative sites proposed by the opponents are zoned EFU and are not within a non-resource zone, so do not need to be considered under the analysis for EFU to be present as a utility in the EFU zone. Some of the alternative sites are extremely complex and burdensome BLM sites. Per previous hearing examiner decisions, which we've included in the supplemental packet, the complexity of permitting issues in those circumstances is enough to render the locations unavailable under ORS 215.275. And indeed, one of those BLM sites was a site that AT&T had previously tried to secure permits on for over 2 years before admitting defeat and moving on to find a different location for this site. Additionally, the Bend Metro Parks and Recreation properties, as well as other area RR10 properties, are restricted by the county's destination resort overlay zone, which only allows wireless facilities that serve the resort property, not the surrounding area. So next slide. And this is a map of the destination overlay, destination resort overlay. The box in green are the properties for the Bend Metro Parks and Recreation District parcel. Next slide. So continuing on with the lack of feasible and available alternatives on non-resource land, the opponents have suggested no existing towers that were available and feasible for co-location. We went and looked at all of the tower sites that the opponents had proposed. These proposed towers were either never built, and we do include pictures of the coordinates with no tower present there, or they lack sufficient height and or strength to meet AT&T's objectives, as is discussed in Exhibit C of the supplemental packet, the enhanced RF justification. Of the towers that do exist, as well as the raw land locations owned by Bend Metro Parks and Recreation District in Oregon State, those fail to meet AT&T's coverage needs, and they are also discussed in Exhibit C. AT&T's demonstration that the RR parcels to the west of the search ring and the MUA parcels to the east of the search ring are unavailable due to burdensome conditional use permit requirements for avoiding visual impacts in these zones. And that's supported by prior county decisions, which we've also included copies of for your for your consideration. The RR10 zone, it's important to note that the RR10 zone requires satisfying criteria related to visual impacts and general compatibility. In this particular area and location, the terrain is very flat, the sight lines are very long, and the vegetation is low and sparse as well. So the chance of being found to be able to mitigate the visual impacts to surrounding properties are very low, and certainly have resulted in denials. In fact, in 2016, Verizon tower in the RR10 zone in this area that was proposed as a 120-foot monopine was denied. Unlike the RR10 zone, the EFU zone does not have a criterion that requires a demonstration of mitigation of visual impacts or compatibility with the surrounding areas. So, and at least one of the board decisions, the conclusion is that a tower proposed for the RR10 zone was probably better off in the EFU zone. And in this case, especially because in this particular location, it's in existing right-of-way that is already unavailable for farm use and is also in a recognized and well-used transportation and utility corridor as well. Next slide. So in summary, AT&T is exempt from a building permit, and the LM zone requirements only apply to projects requiring a building permit. So we withdrew our application for a building permit and asked that the examiner find that the hearings officer find that the provisions of the LM zone do not apply to this project. With respect to the second question, AT&T has demonstrated that this proposal is a utility facility necessary for public service in the EFU zone by demonstrating that we meet 4 of 6 factors when a demonstration of only 1 is required to be found to have met the criteria in this particular code section. Next slide. As a result, AT&T is requesting that its application for a wireless facility at the proposed location in the EFU zone be approved. And with that, I, along with my colleagues, Meredy and Ken, are available to answer any questions the hearings officer might have. Thank you.
All right, thank you. I think one question I want to ask is about sort of the dual or the potential dual nature of the proposal. I didn't hear it as much in your testimony tonight, but the application sort of presenting this both as either a utility facility necessary for public service or a right-of-way improvement. There's comments in the record now sort of asserting that you got to comply with both. And I wonder if you have a response to that now, and if not, I mean, maybe something you can address in writing, but I'd like to kind of hear your position on whether or not both are required to be shown.
Oh, we absolutely assert that it's an either or path to be able to cite in the EFU zone. Both are certainly not required under the plain language of the statutes and under no existing case law that we're aware of.
Okay. And then one thing, this is again more from your written comments. What I was trying to follow was on the utility facility analysis. You have some statements in your submittal from yesterday about, I guess, either the appropriateness or kind of the scope of an alternatives analysis, and that it really only applies to, I think what you were saying was it only applies to one of the factors under 215-275. And I wasn't following that. I kind of wanted to get your position on that, if it's sort of what maybe what your textual argument is for that, as opposed to an alternatives analysis needed for the kind of the larger analysis, including those other factors that are set forth in the statute.
Right, and I think that the beginning part of 215.275 that says you must explore reasonable alternatives. I think that the factors listed subsequently, the 6 factors, are the reasonable alternatives that this particular statute wants you to consider. So there are a number of different options. But one of the things that's not included in there is an analysis of visual impact to surrounding properties. Now, in ruling out the other, if they're in demonstrating that there are no alternatives, reasonable alternatives on non-EFU land, that piece of the discussion comes back into play because it is a required criteria in the RR10 zone that you show visual compatibility. But it's our position in complying with 215.275 that we do not need to have the detailed analysis of visual impacts to neighboring properties that's required for approval in the RR10 zone.
Okay,
If that makes sense.
It doesn't, and I appreciate that part of the comment. I think I'm inclined to agree that from 215 to 275, it doesn't mention anything about visual impacts. But I guess what I'm trying to tease apart is, and let's look at just that statute and not how it relates to the RR10 or any other zones. But so, for example, the factor about the availability of the right of way, if there's available right of way that's outside the EFU, is that an alternative you're supposed to consider? I mean, it sounds like you're attaching alternatives just to the inside or outside of a resource zone, but doesn't it? The text seems like it applies to all the factors depending on what the facts are. So I want to make, because I think one of the things you said tonight was that by virtue of being in the right of way, even just for 215, 275, that's enough, regardless of what other alternatives there might have been.
Right, because the factors are independent. It's an or, not an and, with respect to the 6 factors. You need to meet one of those to demonstrate that it's necessary for you to be in the EFU zone, that you're a utility that's necessary for that zone.
Okay. I think that's all the questions I have for you. I may have more if there's a rebuttal, but for now, we can move on to the next phase.
Thank you.
And Mr. Regini, still no one has signed up in support.
No one has sent in support. I did receive an email from Gary Sherman, who is also joining us via Zoom, who would also like to testify in opposition. So I've added one more name, Gary Sherman, to the list. And what I can do is, if it's reasonable for you, I can have him come up after Dan and Diane, and then get his address and do that part of the record keeping.
That makes perfect sense to me.
Okay, producer, if we could move the applicants back to attendee status, and then if we could elevate Mr. Kierans, that would be fantastic. Dan, it looks like we've got you on screen.
Can you hear me?
We can.
Great, thank you. Is it time?
You may proceed.
Great, thank you very much. My name is Dan Cairns. I'm an attorney. I've been hired by some of the property owners on K-Bar Road to look into this application and to represent them in opposition to the application. I submitted a memo prior to the last hearing. I think you have that in the record, Mr. Brooks.
I do. Thank you.
The 8th. And I haven't submitted anything since then, and I haven't seen anything since then in the record until this morning, when I saw for the first time a new 15-page memo and 92 pages of exhibits from the applicant. And that's why I requested a pretty significant open record period. And let me kind of provide some justification for that. Prior to this, I don't know how long the application has been pending, but prior to this, the applicant's sole focus for getting out of the LM overlay was based on Brent Maher versus Jackson County, 1992 case. And basically it said that for subsection 1 uses in 215-283 and 215-213, that subsection 1 uses are allowed outright. Local governments cannot impose any purely local additional criteria on the siting of those things. Only state law controls the siting of those things. Subsequently, pretty quickly after Brent Marr, LCDC versus Lane County, I think it was, clarified that that doesn't exempt subsection 1 uses from having to comply with other state law requirements that are implemented by local governments. And that's exactly what the LM overlay is. It's, and I practice in quite a few jurisdictions, and I've never seen a jurisdiction that has such a complete, comprehensive, and formal scenic overlay inventory under Goal 5. It's not many jurisdictions have scenic resources inventoried under Goal 5 at all. Deschutes County does. It's had it for a long time. And Highway 20 corridor is one such Goal 5 scenic resource. And so the applicant got a 1-month extension in order to cook up a new argument and a lot of new evidence to support that argument. And so I would ask for an equal amount of time for me to dive in and see exactly what the basis is for ODOT's conclusion that this is right away, as opposed to just fee simple ODOT state property, and the county's building official a simple 2-line email saying they're not going to require a building permit for this use. Mr. Regini told you, and I would respectfully disagree, that if there's no building permit required, then the LM overlay does not apply. That's your call. You are the finder of fact and the interpreter at this point of the code section, and it's 18.84.050 sub A, which talks about what kinds of things implicate the LM overlay requirements, and that's where mention of building permit is found. So you decide that, and it has not already been decided. So I would, I can't really say much about the new argument that the applicant has come up with, other than I need time to look into the evidence that they have submitted in support of it. But this has been a pretty significant shift in their legal strategy in getting this thing cited. I see also tonight that there's an awful lot of talk about FirstNet. I don't see any FirstNet facilities in the plans. There are no antennas proposed. I think this is kind of a sham, and they're using this as a way to justify what is basically a private for-profit company citing another cell tower. They're not providing really any public safety service here. There's no provision for antennas. City of Bend doesn't subscribe to the FirstNet service. FirstNet coverage, from what I have seen, is adequate in this area. So this is just not really a factor in this. This is a cell tower. It's your garden variety cell tower. They withdrew the building permit from this past week that had previously been submitted. So up till that point, the applicant clearly assumed they had to get a building permit for this. So we'll look into that as well. One thing also, in terms of the alternative sites, I don't really agree with the applicant's textual interpretation of ORS 215-275. It requires, let me flip to that. Subsection 2 requires a demonstration that the facility is necessary for them to be sited there. It must show that reasonable alternatives have been considered and that the facility must be sited in an exclusive farm use zone due to one of the following factors. So that's an and, it's not an or. So alternatives, reasonable alternatives is always going to be required in addition to the factors. Also, this applicant has, there are a number of non-resource zoned properties within their search ring, but they have categorically eliminated all of the RR10 and MUA zones because of permitting that has to happen, and they cite previously failed attempts to do that. Each one of these is very site specific. You know that you can't just, oh, it's impossible to site a cell tower in the RR10 or the MUA zone. That's crazy. Those are uses allowed in those zones, and each application rises or falls based on where you put it, the specific locational requirements. And so I think it's not a reasonable alternatives analysis to exclude those non-resource zones. Also, they've eliminated all BLM land from the consideration, as though all BLM land is subject to the exact same management requirements, which it isn't. I think there are within a mile or so of this site, there are like about 11, almost 20,000 acres, 20,000 acres of BLM land. And it's a no-go for any of that. That's crazy. Again, BLM has management plans that apply to different areas, like around BLM campgrounds or BLM specific use or management areas that may preclude sites, towers such as this. But it's, again, disingenuous to eliminate all BLM land, all 20,000 acres of BLM land from consideration, just because they found a piece of ODOT property to site this in. So those are the kind of preliminary comments I have tonight. My memo kind of covers this application as it existed a month ago, and I respectfully ask for 28 days. We'll keep it an even multiple of 7 to respond to the over 100 pages of materials that came in this morning, or I guess last night after 5. That's what I have to say for this evening, Your Honor.
All right. I do have a few questions for you.
Sure.
I'd like to get, I guess, a little bit more flavor of your position. This is kind of what I asked the applicant about with the either or versus, together needing to show both the utility facility necessary for public service or a right-of-way improvement. And I think your written materials either stated or implied that it needed to meet the utility facility requirements no matter what. And I just wanted to ask for more detail on that position of why it can't be one or the other, why a singular use would need to satisfy 2 categories of uses.
McCall Communications told us all that cell towers are utility facilities necessary for public service. And I've never heard of anyone making this alternative argument that this applicant has. I wouldn't say they've exactly abandoned it, but certainly it's not their first choice argument in getting this thing in. Let's see. So they would have to meet both of these. They've increased the burden if they want to bring this in. I think that their argument for find the alternative that they've got here. The alternative that they've come up with is it might pave the way for the equipment cabinet, but not a cell tower. So it talks about normal utilities that are part of a right-of-way project. And I've never heard of a cell tower being that. So the equipment cabinet, maybe that is the avenue for getting in, but I don't believe a cell tower qualifies under the rubric that they're asking for. So that's partly why you need both. It's the cell tower part of it that everyone cares about. Equipment cabinet, that might qualify under the alternative that they came up with.
All right. Another question for you based on your submittal and a little bit of what you said tonight. And this has to do with the alternative sites. And what I understood the applicant to say in response to, for example, the BLM sites was that those weren't necessary to be part of the analysis because they were EFU, not necessarily because they were owned by BLM or there was complexities there. But is it your position that they need to consider alternative sites within the EFU?
No, I don't believe so. If this is an EFU site, I don't believe so. EFU is EFU as far as state law is considered.
Okay.
The alternatives, I guess when you're subject to a visual impacts analysis, that is less zone dependent. But this is not one of the zones that requires a visual impacts analysis unless the LM overlay applies.
Okay, thank you for clarifying that. The other piece I wanted to explore a little bit is this idea that the LM implements goal 5. And I appreciated your comments about the county having a kind of a robust inventory and implementing the scenic resources through the LM. I'm trying to get a sense of though the distinction between kind of what's a statewide goal or mandate and what's a local provision. So does goal 5, does goal 5 require the county to have the LM combining zone, or what's the actual mandate there?
It depends what the county wants to do. I mean, most jurisdictions don't have any scenic resources that are inventoried under goal 5. But if you're going to do that, you go in, if a county decides to undertake that, they have to follow goal 5's requirements, the whole ESEE analysis, which Deschutes County did here. And then after you've evaluated the quality and quantity of each of the resources you've identified under the ESEE analysis, the county then decides which it wants to preserve, which it wants to get rid of and allow to be developed inconsistently, and which it wants to conditionally preserve. And in this case, it decided that the Highway 20 corridor, a quarter mile on either side of it, was worthy of preservation. And that's why it adopted the LM overlay and applied it to it. So it didn't have to, but that's what it did. That's kind of the series of choices that the county made at the time. And it used the LM overlay as a way to preserve these scenic resources. So certainly kind of a get out of jail free card to allow any construction within on this site without a building permit, and therefore claim that it's exempt entirely from the LM overlays at a minimum, inconsistent with what the county was trying to do, with the purpose and policy behind the LM overlay under goal 5. It's a preservation statute, preservation rule, and it's a preservation program as implemented by the county, and it's not preservation for cell towers.
Kind of one final question, and this is just I just want to make sure I get clarity on all of the positions you've taken, and this has to do with your written materials. Well, maybe this is what you were mentioning early on about the gap in FirstNet coverage. I mean, does the utility have to show, or who has to show a need for the utility line? In your mind, what's the standard for whether or not the utility is needed? I'll tell you, because my understanding of how 215 ORS 215 works with the utility facilities is that the necessity component is the necessity to be in the farm zone. The county doesn't really look at the necessity of the utility kind of in a bigger picture. But I just want to, I didn't know if you were, if your point was that they haven't shown a need for this, or just that maybe, like you said in your opening comments here, that the need that they were describing didn't comport with the record.
The whole FirstNet argument is totally irrelevant. You're correct that under McCaw Communications, the necessary element of utility facility necessary for public service was, is it necessary that it be put on EFU land? And so to kind of open and lead their presentation with FirstNet, that, unless this is approved, babies will die. I mean, you're a land use lawyer. It's totally irrelevant.
Okay.
And there's no evidence to support it. I don't see any antennas in their plans. I don't see any provision whatsoever in this entire application for FirstNet, other than that's what they're leading with tonight. This is a FirstNet system that they're setting up. It's not. It's a garden variety cell tower.
Okay, thank you. I think that clarifies what I was reading in your comments. I don't have any other questions for you.
Okay, thank you.
Okay, thank you, Mr. Kearns. At this point, I'm going to ask the producer to move Mr. Kearns back to attendee status, and I'd like to go to Diane Burns, who's in person. If we can get the camera on Ms. Burns. Diane, you're up.
Okay. Hearings Officer Brooks, my name is Diane Burns. My husband and I have lived at 61415 K-Bar Road on our 20-acre EFU AL zone property since 1989 and moved to rural acreage property for the quality of life issues it affords, including wonderful open spaces, unobstructed mountain views, and peaceful natural lifestyle. We would like to keep it that way. Concerning our cell service, we have never had any issues with our cell service from our home. Concerning FirstNet, on many occasions throughout the 31 years we've been there, we have had many occasions to call police and fire, and the response time was immediate. We strongly oppose the location of this tower because of the intrusive visual impact it has from our home and our neighborhood, as well as the significant loss in value in our homes due to the close proximity of the tower. The applicant has not met and has failed to address the standards in DCC 18.128.34 B and 2, and number 5 concerning the siting of the tower. 5 states, in all cases, the applicant shall site the facility in a manner to minimize its impact on scenic views, and shall site the facility using trees, vegetation, and topography in order to screen it to the maximum extent practicable from view from protected roadways. Towers or monopoles shall not be sited in locations where there is no vegetation, structural or topographic screening available. There is no screening near the tower, and it is totally exposed to all traffic traveling east and west on Highway 20 and to nearby homes. The tower site is located within the Deschutes County EFU Landscape Management Overlay Zone, which protects our scenic views and aesthetic values. Building a cell tower on the right of way near scenic highway conflicts with section 18.16.060 under dimensional standards. No building or structure shall be erected or enlarged to exceed 30 feet. AT&T's land use application consideration of reasonable site alternatives is extremely weak. To name a few examples, alternative site 1, the Oregon National Guard site, fell out of consideration due to the complexities of addressing the needs and fulfilling the requirements of all the federal and state issues involved. You're telling me that a $200 billion company with its numerous attorneys, construction divisions, real estate divisions, engineering divisions, and more couldn't navigate through these federal and state issues? That's hard to believe. In site 2, alternative number 2, AT&T cited, among other issues, high development costs. I personally know numerous property owners who purchase rural bare land and deal with the high development costs that are factored into every project. Alternative site number 3 says AT&T rejected the property because of unreasonable high rent demanded by the property owner. Is that the only property owner approached by AT&T concerning a possible site? It would be interesting to see what ODOT contracted with AT&T to see what their idea of a reasonable rent entails. Unfortunately, those numbers are redacted in the ODOT contract. Under AT&T's MUA property alternative site search, AT&T admits on the MUA site that was rejected by AT&T, and I quote, "The trees in the area are relatively small, 30 to 40 feet in height, and the site lacked natural features to screen the tower. The proposed AT&T site on Highway 20 in our neighborhood has no, I repeat, no screening from Highway 20 traffic and neighborhood homes. I am confident that with their wealth of resources, AT&T should be able to locate a more suitable site that will not negatively impact our neighborhood and surrounding landowners. The Oregon Department of Aviation has recommended marking the lighting on the 150-foot cell tower with marking and lighting on the 150-foot cell tower, which will further impact our nightscapes with unsightly lights obstructing views for miles around. The Kennel private airstrip located within close proximity to the tower is a safety concern. The smaller, slower planes that use private airstrips take off and land while flying at lower levels. The tower is in the Kennel airstrip flight path, and the safety of the pilots could be endangered along with residents, property, and those traveling on Highway 20. We have been real estate brokers in Central Oregon since 2000 and realize that location is a top consideration for a buyer of residential and especially rural properties. These buyers' expectations are not always able to be verified with statistics, but it is well known to us and other realtors who are often directed by buyers to pass on viewing a property because of unsightly wires, cell towers, and other view and neighborhood obstructions. It is always the visual characteristics and private settings that draw buyers to purchase a specific rural property. Also, views and location are always weighed heavily on an appraisal and could be as much as 10 to 20% less in appraised value for obstructed, unsightly views from a home. Property within view and range of the tower will be impacted with a decline in their property values. AT&T has provided photos of the tower site, which only show views of the tower by traffic traveling east and west on Highway 20, and no photos of the visual impact the tower will have from neighborhood residents' homes, which is extremely negative. We see the cell tower from inside our home. We see the cell tower from our front and backyard. We see the cell tower from our fields, and we'll see the 150-foot monstrous eyesore of a cell tower as we travel back and forth to Bend every day. Also, AT&T's sketch of the tower, Exhibit A, and their photos do not show the additional 18 or more panel antennas, which will be used by other carriers, further degrading our scenic views, but greatly increasing revenue for AT&T. We hope that this proposal is denied and does not set a precedent for placing cell towers up and down our scenic highways throughout our beautiful county, and state. Thank you for your consideration.
Thank you, Ms. Burns. I don't have any questions for you.
Mhm.
And producer, if we could go ahead and elevate Mr. Sherman. And then Gary, when you get on, if you could repeat for the record your address, please.
There we go. Can you hear me?
We can,
Hear you.
Gary. We get your address?
61585 K Bar Road, Bend, Oregon, 97702.
Thank you, Gary.
What I'd like to do is just share my screen. I apologize. I wasn't going to comment anything, but some of the things that Miss Allen said are kind of, they irritated me enough where I thought I would give my PowerPoint presentation to show that some of the things that she stated are absolutely totally incorrect. So what I'd like to do is share my screen real quick. And I get a PowerPoint presentation, and I will try not to take up too much of your time. Screen one. I'm not used to doing all this stuff, so I apologize. Share. Can you see my screen?
Can see it.
Yep.
It says AT&T cell tower.
It does.
Can see it.
Okay. At the very beginning of the presentation, Miss Allen commented on the fact that there are light structures. We took a drone and we flew it up 150 feet, and this is what you see. And I would like to see anywhere on this video where there are other type features of a cell tower that are present. And I would like you just to look at this, because this shows exactly where this tower is going to be, and anything that you can see from this 150-foot location will also be able to be seen by anybody out in that vast open land. There's Highway 20 right there. Those people are going to be driving down the road, and there probably will be more accidents than there already are out here from the distraction that's going to cause. So I'm just going to let this play a little bit, because again, there are no cell towers out here. There are small telephone poles, but everything is very flat. And as you can see, the trees are almost non-existent, very sparse. So there's absolutely zero coverage to protect this tower and shield it from view. And again, this is right down on their site. And at the very end of this video, you can look down and it shows exactly where the cell tower is going to be put. And you will see zero, almost virtually no coverage whatsoever to shield it. Mr. Cairns has already presented all the other arguments as far as the Goal 5 overlay. And so I'm just showing this so everybody can at least see where this tower is going to be. There are the trees. They're right there is where the tower is going to be, where that little tiny tree is going to be, which they'll even have to just knock that down before the tower goes up. So that's the part I wanted to show you. The rest of it I'm going to skip over, because Mr. Cairns has already commented on all of this stuff. This is a view from my house of what I see right now. That's what the cell tower is going to look like. It's blatantly obnoxious. It's not, there's no screening whatsoever. It's like wake up, walk outside, and every morning get hit in the face with this thing. This is one of my neighbors in back of me. That's what he's going to be saying. This is what it looks like right now by Mrs. Burns' house. This is what she's going to be seeing. Absolutely no coverage whatsoever. Here are all the affected homes that are around here. They're all within 1,000, 1,500 feet. Some of them are 3,000 feet. All of them, everybody's going to have a monstrous just eyesore in their backyard. One of the main reasons I wanted to comment is, again, this FirstNet. This is AT&T's own coverage map showing the FirstNet, and the dark blue, this blue represents very, very good coverage. There's Highway 20. The entire corridor has terrific coverage already. Furthermore, Bend just recently upgraded their radio system. I spoke with a representative from the county, and Ben has no plans of going with FirstNet. It's an individual city by city decision based on the coverage versus the return of the money, basically what they get. And again, they just recently upgraded their system less than 3 years ago. and it was all over the newspapers, and they spent a tremendous amount of money getting the communications up and going. So again, I believe AT&T is absolutely falsifying this. They're billing it as a FirstNet and a public utility and deemed necessary. And I do not believe it. According to AT&T's own maps, it's not true. Another factor which AT&T has not seen is this flooded last year. So their vault is probably going to have to be raised at least 6 feet to 10 feet. We had a rainstorm out here last year that it inundated the entire area with floodwaters out here. I don't even think AT&T even knows that is part of their potential hazard for them. Again, Ms. Burns kind of spoke about this. In 75%, under no circumstances would anybody ever purchase a home or rent a property within a few blocks of a cell tower. Our property values will, I know it's not part of the criteria, and I know you can't base your decision on this, but it sure impacts us. And it's kind of funny, this just recently came up today in India. In 2012, cell towers are removed from schools and hospitals because of their potential hazards. And I know, again, that you can't make a decision on this. In 2000, and I think it was 18, they actually had them being removed from prisons. So it's safer to be in India around cell towers than to have one 700 feet away in your backyard. Again, that's all I have. That's the end of my presentation. We just hope that you guys come to the right conclusion in this cell tower.
And thank you, Mr. Sherman. I don't have any questions for you. I do assume, have you provided the PowerPoint presentation to the county?
Mr. Sherman, what I'll need from you is both electronic and hard copy of the PowerPoint, and then particularly the video, whatever format you have of that, I'll need that for the record so that the applicant or others can view it as well. So if you could get those to me relatively quickly, that would be fantastic.
Sure, be more than happy to.
Thank you. Hearings Officer Brooks, did you want me to have the applicant elevated for rebuttal at this time?
Yes, please.
So let's go ahead and same trio, Kim, Ken, and Meredy. If we could, producer, that'd be awesome.
Can you hear me?
Can hear you.
Very good. Hearings Officer Brooks, we would just like to address a couple of the points made in rebuttal. With respect to cell tower that is being proposed to be sited in the right of way and not requiring a building permit, we'd like to direct your attention to Exhibit D in our supplemental filing, which is in the matter of CU 96-85 regarding a conditional use permit. This is the Western PCS case, and the board there finds that they need not resolve Brent Maher, and did find that because this work was being located in a public right of way and didn't require a building permit, that the LM overlay did not apply. So we would direct your attention there. With respect to the FirstNet issue, I believe, with all due respect, that Mr. Kearns perhaps doesn't understand what that network is going to be as it builds out. So if with your leave, we'd like to have Ken Lyons address that, because he's been instrumental with AT&T and helping to build out that network.
Sure.
Good evening, Mr. Hearings Officer. So I do want to address a couple of things that was stated. There's extensive information in the application that deals with FirstNet. I just want to make sure that's clear. It's addressed in the narrative. It's certainly addressed not just in the PowerPoint presentation this evening, but there's information in the record as such. The other thing that I think it's very important to note is that AT&T and we have a significant gap in coverage. That's certainly what the And we have the attestation of a qualified RF engineer and exhibit in the record that basically describes the significant gap in coverage that we have here. That significant gap in coverage covers a number of different frequency bands, which includes band 14, which is the FirstNet specific frequency. The drawings as well, a band 14 antenna is a 700 megahertz band. So it's basically the same antenna, some very similar antenna to other 700 megahertz antennas. So those are shown and depicted on the drawings. So I just want to be very clear that one, there's a significant gap in coverage. That information is in the record. You can certainly see the area that doesn't have service that would be filled with this particular facility. There's extensive information in the record as it relates to FirstNet, but also, I can also speak directly to the fact that this was one of the sites that the state SIEC had noted was an area of poor coverage needed to be improved. There's a number of first responder agencies, not just the city of Bend, certainly, but certainly the county, other fire districts, there's certainly the state, the federal government. They're all effectively, there's a number of different FirstNet users certainly in the area as well. So I just wanted to speak to that particular issue, and I'm certainly happy to answer any questions related to that. Thank you.
Thank you.
Back to you, Kim.
Kim,
Ms.
you're,
Allen, you are still muted.
Yeah, thank you. I think that's just about it. The points raised by Ms. Burns and Mr. Sherman are points related to visual impacts, which don't factor into the assessment of whether a facility should be placed in an EFU zone under 215.275. And to the extent that Mr. Kearns wishes to have an extension of time to respond, we're not necessarily opposed to that, but 28 days takes us, I think, squarely into the holidays in terms of that. And 21 would maybe be a little, provide a little bit more opportunity to respond. So we would propose 21 days.
Okay, thank you. I was just about to ask you if you had a position on that. All right, anything else from the applicant by way of rebuttal?
Not at this time.
Okay. Mr. Regini, I don't have specific questions for you, but I give you the opportunity if there's anything that staff would like to present in response to what came up tonight, and then we can talk about the schedule.
Staff doesn't have anything to add. I was the only really the note that I had was it was unclear until Ms. Allen spoke to it just now. My concern was if the applicant did not agree to the open record period, where will we be with the federal shot clock, more particularly than the 150-day local clock? And so depending on what the hearings officer does here, I think if I did my math correctly, and I sort of did this with Mr. Kearns earlier today, I think today for the federal shot clock is day 41, if I've counted correctly, and certainly somebody can correct me if I'm wrong. And so that was my primary concern when I saw the request for 28 days is what would be the applicant's posture with regard to the open record period, because certainly the federal shot clock is much shorter than the 150-day clock, and it starts at different times as well.
Yeah, well, let's have a discussion about that. So my inclination is not to go 4 weeks. I think 3 weeks is probably enough. I think a lot of the information that the applicant provided yesterday, at least a good bit of it was in response to the issues that had already been raised anyway. So I don't know that it warrants a whole new diving into. But I also am cognizant of the general slowdown around holidays. So if it meets if we might need to do the math on the federal side. If it meets that, I would like to do leave the record open for 3 weeks, which takes us to the 28th, but then give of course, a week rebuttal, which is the 4th, and then a week for the applicant to give a final legal argument, which is the 11th of January. Let's see, that's 35 days to your 41 days. which makes it what, 76 if my lawyer math is right.
Well, one of the things I was going to ask is because I don't know the answer to it is it's unclear to me if the applicant agrees to the open record period, is there the same effect on the federal shot clock as there is the local clock? And I ask again because I don't know the answer to the question. And it looks like Kim has her hand raised.
Right, I understand. Maybe we could, yeah, if we could know
I can.
if
Uh,
that time frame.
Yeah, I have not calculated the shot clock specifically. The shot clock in this particular this particular case has is 150 days under the federal shot clock, the same as yours. I think so that Mr. Regini's calculations mean that there are 41 days remaining of the 150 days under the shot clock.
So my calculation of the 41 days was under the assumption that the continuance period from November 9th to today extended both shot clocks. And I don't know that actually that's correct. And so that was one of the questions I had is it's unclear to me what the continuance did to both clocks. And so I calculated 41 days, assuming that the time period from November 9th to December 6th, essentially yesterday, extended that clock. And so that would mean today, well, or if you want to use the term told the clock, today would be day 41 on the federal, because if I'm not mistaken, the federal shot clock begins on the date the application is submitted, as opposed to the county's, the state statutory clock, which is the 150 begins after it's deemed complete. So we actually have two different timelines running. So again, I made a number of assumptions, which may or may not be correct.
Mr. Regini, I don't like to do lawyer math either on camera. so if we could respond to the shot clock question separately, that would be helpful.
Sure.
As you say, the calculations are different.
Sure. I just wanted to raise it for the purposes of this discussion, because again, if in fact the continuance from November 9th to December 6th, and then this open record period does not toll or extend the federal shot clock, then we're much further along than I think.
Okay. Well, in the event that we are approaching either the federal or the state shot clock, we'll certainly entertain the request for an extension of that. But I don't think we're there yet.
Let's take a break and pause for like 2 minutes. Let me look at something and then I'll be right back to you guys. 1 second. Okay, thank you. Thank you for indulging me. I was going to see if I could answer one of those questions sort of on the fly, but I don't think I'll be able to. So it sounds like through the colloquy with the applicant that the extended record period is it's got two components. One is both that the applicant has agreed to that. So for purposes of the county's own time frame, it would extend the deadline for making a decision, but that the applicant feels that there's enough time to still respond to the federal shot clock. So in the case
Hearing also-
with that
Breaking up a
with
little
that
bit.
time frame.
Yeah, hearings officer Brooks, your audio
Oh.
is now.
Okay. Let's see. Maybe that should be a little bit better. Are you able to hear me now?
Yeah, you're coming in clear now that your
Okay.
video is off.
Yeah, maybe I have to get a new computer. So I don't know where you lost me, but I was saying it sounds like from the applicant standpoint, the extended record period does work for the time being. So unless there's other information from the applicant that it doesn't, I think we should proceed with that 3-week, 1 week period. Ms. Allen, can you confirm, I guess, that it feels like it worked? Okay.
Yes, we have plenty of time under the federal shot clock.
Okay. Thank you. So with that, then we'll close the now, except for we'll leave the record open. I'm gonna a little bit, and then I think Mr. Regini will probably provide some instructions about submittals within those time periods. So let me get my calendar back up here. And we will, pursuant to the applicant's agreement, we're going to extend the written record only for a period of 3 weeks until December 28th. During that time period, any participant can submit materials to the record. We will then have a 1-week rebuttal period, which goes until January 4th of 2022. During that time, any participant can submit information what is already in the record at that time. And
Hearings
then
officer,
there'll be,
mind repeating that last sentence? You cut out again.
yeah, I'm
During
really
the
sorry
rebuttal
about
period.
Yeah. So for the rebuttal period, that goes until January 4th. That is for any participant to provide additional materials, evidence, or argument to the record, but solely for the purpose of rebutting information that is already in the record as of that time. And then it will be a final period, 11th, for the applicant to submit a final legal argument with no new evidence. Did all that
Yeah,
clear?
you cut out a little bit, but I think I can repeat the last period, which is final legal argument solely for the applicant, ends on January 11th, 2022. Did I capture that correctly, hearings officer Brooks? And now we're not getting any audio from you.
Anthony, I apologize. Yeah, can you hear me now?
I can.
I think it might be best for me to call back in. I don't know if you need, will that mess up my panelist status if I call in using the number?
No, we'll just elevate you when you call in.
Okay, let me do that. I don't want to have any misunderstanding on these instructions. So hold on one second.
I don't hear you. And I don't see your phone number coming up on the attendees list either.
How about now?
I can hear you fine over the Zoom, but I don't see your phone number showing up on the
Oh,
list.
it gave me the option to connect it to the same video, so it should
Okay.
be all good. Okay. Again, really apologize for that. So where we were left off was on describing the rebuttal period. The rebuttal period will go until January 4th, 2022. And the rebuttal period is for any participant to provide materials, either evidence or argument, but solely for the purpose of rebutting information that is already in the record as of that time. And then there will be a final period until the 11th of January for just the applicant to provide a final legal argument with no new evidence. Did that come through?
It did. It did.
Okay.
Looks like Kim has a question. Kim, you're still.
do. Am I muted?
No, you're not.
Okay. Just so I understand the rebuttal period, is the instruction that any party can introduce rebuttal evidence for anything that's in the record, even the things that are in the record as of today, or is it just for any new information that might be submitted into the record on or before 12/28?
Yeah, the way I described it was for anything that's in the record as of that time.
Okay, thank you.
Okay, so with that, Mr. Riggini, do you want to provide the instructions for submittals during those various periods?
Yeah, so one last screen share from me. And again, this is, as Hearings Officer Brooks stated, this is sort of instructions, or I guess I call them instructions and cautions with regard to the open record period. So if you are contemplating submitting a link to a website or personal cloud storage device, understand that the county does not take any responsibility for retrieving the information from the link or website. And so what we will do is print your materials that have the link and personal cloud storage device address, but we will not retrieve it. So it's your responsibility to submit anything in the record that you'd like Hearings Officer Brooks to consider. Something I mentioned earlier, particularly with email submittals or electronic submittals, if it exceeds 20 pages, is color or must be printed larger than 8.5 by 11, then you have to submit a hard copy as well. We'd certainly appreciate the electronic submittals, but if you exceed any of those thresholds, then you'll have to submit also a hard copy. When you submit either email or written submittals, should be to my attention. And then the last thing, and this has gotten some parties sort of upset in the past, is, and I always caution folks to, when you submit information to the record, particularly electronically, do so well before 5 o'clock. I've had a number of cases where parties have submitted emails to the record, and it's clear from the data that we get from our IT department that it was sent prior to 5, but it was not received by the county servers by 5 p.m. So the timestamp that we use is received by the county server by 5 p.m. So again, I encourage everyone to participate and submit their evidence and testimony, but please, particularly for electronic submittals, do so before 5 p.m. And so those are, again, my sort of cautions and instructions. If you're submitting by email, I have my email address on the screen, and I think most of you have already contacted me via email, so you have that. And certainly I'm available for questions during this open record period.
Okay, I think that concludes everything, unless there's anything else that I need to use my attention.
I don't think
Look like
so.
it. All right, then we will go off the record at 7:39. Thank you.
Thank you, everyone.